All right, looks like we've got a nice docket today. Are you guys ready to tackle this?
Let's rock and roll.
All right. Well, good morning, all. This meeting is called to order. Mr. Trobman.
Good morning, Commissioners. We have no registrants for public comment this morning.
Thank you very much, sir. Good morning, Ms. Miller.
Good morning, sir.
How are you today?
Doing very well, thank you.
Well, that sounds great. On agenda item 3, no cases to reconsider?
That is correct, no cases.
All right. No tax liability cases on agenda item 4 either?
That's correct, not this week.
And fair housing cases on agenda item 5?
No, sir, no cases.
All right, wage claim cases on agenda item 6. We do have one pulled for additional.
Yes, sir, we have one case pulled. It's case number 19-059583-8. Commissioner Alvarez?
The decision is not supportable. I will not contest the ruling as to good cause. Regarding the underlying issue, the appeal tribunal did not apply the appropriate standard. 29 CFR section 785.11-785.13 requires that if an employer knows or has reason to believe work is being performed, it must be counted as hours worked, even if the work is performed off the employer's premises. Further, it is the duty of management to exercise its control and to see that the work is not performed if it does not want it to be performed. Here, the employer's client was approved for 7 days of care at $27.50 an hour of care per week. The employer had been providing the care through 2 employees. When one of the employees retired, the claimant took over all care. The claimant has provided firsthand testimony that she was approved to do so by an individual who worked for the employer. The employer has not provided firsthand testimony to refute this. Even if the employer did not specifically authorize the claimant to take over, they should have been aware she was providing the work they were contracted to perform, as they did not assign any other individual to perform the work and had received no complaints for the lack of performance on their part. The claimant has provided testimony from 2 disinterested witnesses who have confirmed she performed the hours worked. The claimant worked 144.64 hours during the period of claim. She was only paid 69 hours. The claimant is entitled to $714.50 in total gross unpaid wages. Regarding the administrative penalty, the employer has several previous adverse wage claim determinations against them and should be assessed a penalty of $714.58. Reverse CAT, good cause, $714.58. Wages owed, administrative penalty of $714.58.
The AT decision is supported based on the record. If there had been proof that the employer was somehow aware of the extra and unauthorized work that the claimant allegedly performed, it would be liable for paying such wages. However, the record does not conclusively show that the employer was aware of the claimant's alleged extra work hours for the client in question. Moreover, the claimant gave no credible, inconsistent testimony or other proof that the employer had authorized her to work beyond her scheduled and documented hours. Accordingly, we should affirm the AT decision. The employer had good cause to miss the first hearing. The claimant is not entitled to wages, no administrative penalty.
Affirm the WCAT. Employer established good cause for WCAT 1. Wage claim dismissed, no wages owed, administrative penalty rescinded.
Short form dissent?
Yes, sir, Commissioner Alvarez. And that is the only pulled wage claim case on this docket. I did a few minutes ago send you the wage claim short form dissent list for docket 5.
I move we accept staff recommendations on the remaining wage claim cases on docket 5.
Chairman, I second the motion except for those cases of which I am dissenting, as reflected on the wage claim short form dissent list for docket 5.
Chairman's motion except for the cases on which I'm dissenting as reflected in the wage claim short form dissent list for docket 5.
Motion passes with the exceptions noted.
Thank you.
Thank you. Let's move to agenda item 7, consideration of unemployment insurance cases on docket 5. Please proceed when you are ready.
Case number 2434657. Commissioner Alvarez.
The AT decision should be modified. First of all, the claimant's appeal to the commission should be deemed timely Because the appeal tribunal did not mail a copy of the AT decision to the claimant's attorney as requested, and because the appeal period for the decision fell within the period in which the agency was experiencing pandemic-related difficulties. On the separation, the AT decision is not supportable. The claimant was absent from work after May 14, 2019, because of a heart condition. The claimant notified the employer of his reason for absence before May 14, 2019, and the employer was aware that the claimant had missed work 2 years prior for the same medical condition. The claimant had an appointment with the cardiologist on June 7, 2019, at which time he received a doctor's note excusing the claimant from work until June 24th of 2019. The claimant gave this note to the employer, but the employer demanded additional medical documentation, specifically covering the period from May 14, 2019 through June 6, 2019. The claimant did not have medical documentation for that time period because he was not able to see his physician until June 7, 2019. The employer ultimately discharged the claimant supposedly for inadequate medical documentation. The claimant kept a reasonable contact with the employer during his period of absenteeism, and the evidence clearly established that the claimant was absent from work due to a medical condition. He therefore should be qualified for benefits, and the employer's account should be protected from chargeback. Deem the claimant's appeal to the commission timely and modify the AT, no misconduct, and no chargeback due to MVI.
I agree that the claimants filed a timely appeal to the commission. I also agree that the claimant's failure to contact the employer as required constituted work-connected misconduct. We should therefore deem the claimant's appeal to the commission as timely and affirm the AT decision. Misconduct, no chargeback.
Timely commission appeal, affirm the AT, misconduct, no chargeback.
Short form dissent?
Yes, sir, Commissioner Alvarez.
Case number 2455973. Commissioner Alvarez.
The decision is not supportable. The employer discharged the claimant because he allegedly failed to report that he had to abandon a vehicle due to flood waters. The claimant provided sworn testimony that he called his manager twice. A hearing was scheduled to provide the employer the opportunity to present firsthand testimony from the manager. The employer failed to appear and provide such testimony. The claimant's sworn testimony carries greater weight than the hearsay offered by the employer. The evidence is insufficient to establish misconduct. Reverse AT, no misconduct, chargeback.
The AT decision should be affirmed. The claimant failed to make an adequate effort to notify the employer about the location of his abandoned work vehicle. Moreover, the claimant's testimony that his prior warnings fell off after 90 days is not credible. The prior warnings were for speeding and running a four-way stop, moving violations that could constitute Class C misdemeanors. It is unlikely that the employer would allow warnings for these violations to fall off the claimant's record, and the employer's testimony supports that assertion. Thus, when the claimant neglected to notify the employer of the vehicle's location, he failed to take adequate steps to protect his job and mismanaged his position of employment. We should affirm the AT decision, misconduct, no chargeback.
Reverse the AT, no misconduct, chargeback.
Short form.
Yes, sir, Commissioner Dimerson.
Thank you.
Case number 2525041. Commissioner Dimerson.
The AT decision should be modified. I do not dispute the validity of claim determination. As to the job separation, the claimant was discharged for renting appliances to a guest without authorization and then pocketing the money. The claimant's denial of this incident is self-serving and not credible. The claimant denied being present when the guest identified the claimant as the person who rented the appliances. However, the employer provided testimony from two first-hand witnesses who each credibly explained that they were present when the guest identified the claimant. These witnesses also provided notarized statements, further bolstering their testimony. The guest also provided a statement explaining how she spoke to the claimant on several occasions about the appliances at issue. The guest did not have access to the appliances on her own and must have acquired them through an employee. And this guest had nothing to gain from misidentifying the claimant. Furthermore, at the time of the incident, the claimant was on a final warning, serving a guest in the middle of the night and demanding to borrow money. Therefore, since the claimant's testimony was credibly refuted by first-hand witnesses, his denial of the final incident is not persuasive. We should modify the AT decision. valid claim, misconduct, no chargeback, adequate employer response.
The the decision should be modified. Valid claim, no misconduct, chargeback, and correct AT decision. The claimant filed a valid claim. Regarding the job separation, the employer only presented secondhand testimony that the claimant was identified by a customer as the employee who she interacted with. The claimant denied the allegations under oath. Additionally, the employer admitted then that other employees had access to the appliances in question. Therefore, the employer presented insufficient evidence of misconduct. Modify the AT, valid claim, no misconduct, chargeback, and correct the AT decision to reflect that the initial determination was reversed.
Modify the AT, valid claim, no misconduct, chargeback.
A short form.
Yes, sir, Commissioner Demerson.
Thank you.
And Mr. Chairman, do you agree with the Commissioner Alvarez's vote to correct the appeal tribunal decision?
Yes.
Thank you very much.
Case number 2569150. Commissioner Demerson.
The AT decision should be affirmed. When the claimant opened the determination, he had 10 days left to file a timely appeal. Nevertheless, the claimant did not file his 17 days later, a week after the deadline had passed. The claimant never explained why his appeal was late, and there was no evidence that the TWC system failures or difficulties in reaching the agency were the cause of his late appeal. Thus, the claimant appeal is late, and we do not have jurisdiction to consider the underlying merits. We should affirm the AT decision, untimely claimant appeal, voluntary leaving, no chargeback.
The AT decision on the timeliness should be reversed. The appeal period in this case fell within the period in which the agency was experiencing difficulties due to the pandemic, and the claimant's appeal should therefore be considered timely. Reverse the AT, timely appeal, and remand to the AT.
Reverse the AT, timely claimant appeal, remand.
Short form, Chair.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 2587418. Commissioner Demerson.
The AT decision should be reversed. The employer's appeal to the first determination was timely, since it was filed before the deadline to appeal had passed. As to the job separation, the parties agreed that travel was a regular occurrence for the claimant as he had worked at several locations throughout his tenure with the employer. Thus, when the claimant was asked to once again work at another location, this did not constitute a change to his hiring agreement. To the extent the claimant had any issues with housing, there is no evidence that he addressed this concern with the employer prior to resigning. Furthermore, the evidence suggests that the claimant refused the new assignment because he had general concerns about COVID-19 and wanted to stay near his mother. Neither of those reasons constitute good cause to refuse work. Therefore, under these facts, the claimant resigned for personal reasons, and we should reverse the AT decision. Timely employer appeal, voluntary leaving, no chargeback, adequate employer response.
The decision should be modified. The employer filed a timely appeal regarding the job separation. The location where the claimant worked was closed by the employer, and the claimant was asked to relocate. The locations offered by the employer were 3.5, 7, or 8 hours away. While the claimant had worked at times at some of these locations temporarily, the employer was asking him to relocate away from his family on a permanent basis. As this was a substantial change to the hiring agreement, the claimant had good cause to turn down the employer's offer. Modify the AT, timely employer appeal, no voluntary leaving, chargeback.
Reverse the AT, timely employer appeal, voluntary leaving, no chargeback, adequate employer response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2594007. Commissioner Alvarez.
The decision is not supportable. The claimant typically worked as a substitute teacher over the summer and had signed up to work the 2020 summer. Due to COVID-19, the employer did not conduct their traditional summer school, and the claimant was unable to work. As such, the claimant was not between terms and should not be ineligible. Reverse AT, no reasonable assurance.
The appeal tribunal decision should be affirmed. The available evidence indicates that the claimant received a letter of reasonable assurance for the upcoming school year. As such, the AT decision that the claimant had reasonable assurance during the relevant break period is supportable. We should therefore affirm the AT decision. The claimant had reasonable assurances from May 31st, 2020 through August 15th, 2020.
From the AT, claimant had reasonable assurance May 31, 2020 through August 15, 2020.
Short form dissent?
Yes, sir, Commissioner Alvarez.
Case number 2608375, Commissioner Demerson.
I agree that the claimant filed a timely appeal. As to the merits, the commission should rehear this case. The claimant was terminated for failing to complete a drug test, which subjected him to immediate termination under company policy. The claimant admits that he left the testing site, but states that he did so because his minor child was in a car accident and that he got permission from the head of safety to leave the testing site. He also suggests that he had proof of the accident, but was terminated before he could prove it to the employer. We should rehear this case to obtain proof of the accident from the claimant and for testimony from the head of safety. In addition, the employer provided several documents in its appeal to the commission, which should be entered into the record before a decision is rendered in this case. Accordingly, we should grant a rehearing in this case for this testimony and documentation.
The decision should be affirmed. The claimant filed a timely appeal. Regarding the job separation, the claimant was asked to take a random drug test. He was waiting at the facility to provide a sample when he found out that his wife and son had been in a bad car accident. He informed the employer of the situation. The claimant was not told that he would be fired if he left the facility. Under these circumstances, it's understandable that the claimant would need to leave the facility to attend to his family emergency. The employer could have allowed the claimant to provide a sample when he returned. Therefore, the claimant's actions did not rise to the level of misconduct. Affirm the AT timely claimant appeal, no misconduct chargeback.
I concur with Commissioner Demerson's to hold a rehearing.
We will rehear the case.
Case number 2608434, Commissioner Alvarez.
The decision should be affirmed. The claimant denied that she was told that she was required to use the share file system for acquiring client documents instead of encrypted email. The executive assistant testified at one point that the share file system was performed for acquiring documents. The employer has never provided documentary evidence to establish that the claimant was trained the system and that it was required by policy. Given the lack of documentary evidence and the testimony that the system was merely preferred, the evidence fails to establish misconduct. Affirm the AT, no misconduct chargeback.
The appeal tribunal decision should be reversed. The claimant was terminated per the employer's progressive disciplinary policy. The weight of credible evidence establishes that the employer followed its policy and the claimant knew she could be discharged when she received her third write-up. The employer stated that the claimant had performed competent work for the company for 8 months prior to receiving the first warning. As such, the claimant's final write-up for failure to communicate timely with the client in light of her previous warnings constituted word-connected misconduct. We should therefore reverse the AT decision. Misconduct, no chargeback, adequate employer response.
Affirm the AT, no misconduct chargeback.
Short form.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 2612517, Commissioner Alvarez.
The decision should be reversed. The employer alleged that the claimant was uncooperative in its investigation, but never provided any factual basis for how the claimant failed to participate in the investigation. The claimant's husband was being investigated for neglect of their child. At the conclusion of the investigation, there was no determination that the claimant or her husband were guilty of any wrongdoing. The claimant's husband obtained assistance for his mental health issues. According to the claimant, after the investigation was completed, without any findings of wrongdoing, the claimant was asked to take a basic parental lean class The claimant declined to take the class because she had already sought community services that actually addressed the issue, which was her husband's mental health. As no evidence has been presented that the claimant was guilty of any wrongdoing with regard to her child, and no evidence has been presented that the claimant declined a service that would increase the safety of her child, the evidence fails to establish misconduct connected with the work. Reverse the AT, no misconduct, bill reimburse an employer.
The appeal tribunal decision should be affirmed. The claimant found herself added as perfect for being neglectful of supervising her child. Investigated. Per the claimant, the employer instructed her to complete parenting classes through one of its providers. The claimant stated that she felt the classes were irrelevant to her and offered to take classes through another provider. Given the totality of the circumstances and the employer's policies requiring the avoidance of any appearance of impropriety, the employer's instructions to the claimant were reasonable. Such, the claimant's actions constituted work-connected misconduct. We should therefore affirm the AT decision, misconduct, reimburse an employer, not billed.
Affirm the AT, misconduct, reimburse an employer, not billed.
Short form dissent?
Yes, sir, Commissioner Alvarez.
Case number 2624495. Commissioner Alvarez.
The decision is not supportable. The claimant did not report to work because he felt ill. People were instructed not to go out if they felt ill to stop the spread of COVID-19. The claimant went to the doctor on March 20th, 2020, and April 6th, 2020, to obtain releases to return to work. The claimant's absences due to personal illness were not misconduct connected with the work. Modify the AT, no misconduct, MBI, void chargeback, employer not a party of interest.
The appeal tribunal decision should be modified. Due to filing a late protest, the employer should be deemed an NPI and the chargeback ruling voided. As to the job separation, the available evidence indicates that the claimant did not call the employer each day he had an absence and did not provide the appropriate documentation to cover his absences. As such, the claimant's activity amounted to work-connected misconduct. We should therefore modify the AT decision, misconduct, void chargeback, designate the employer as an NPI, and correct the AT error.
Modify the AT, misconduct, void chargeback, employer is not party of interest, correct error in AT decision.
Short form dissent?
Yes, sir, Commissioner Alvarez.
Case number 2625376. Commissioner Demerson.
The appeal tribunal decision should be modified. The evidence in the record indicates that a couple of days after the claimant last worked with the employer, he was admitted into the hospital for emergency surgery. Upon the claimant's return, he attempted to provide medical documentation to the employer and was told that the employer was under the impression he had quit. Thus, a separation appears to have occurred while the claimant was dealing with the medical issue. Accordingly, the claimant should be qualified for benefits and the employer's account should be protected from charge since the job separation was the result of the claimant's medically verifiable illness. We should therefore modify the AT decision, no misconduct, no chargeback, MBI.
Ms. Miller, I would agree with Commissioner Demerson.
Agreed.
Thank you. We have a unanimous decision.
Case number 2630399. Commissioner Alvarez.
The claimant's motion for rehearing should be granted. The prior commission decision set aside and the AT decision should be reversed. The Texas Workforce Commission has repeatedly informed the public during the pandemic that unemployment claims be dated back when the claimant became unemployed. Executive staff have also given interviews stating that we would use the last dated work as the basis of the claim instead of when it was filed. To prevent injustice, Rule 22 should be applied to this claim. Grant the MR, set aside commission decision, and reverse the AT decision, the initial claim backdated to March 15, 2020.
Because the claimant's motion does not meet the criteria for a successful MR, we should deny the claimant's motion for rehearing.
I concur with Commissioner Alvarez.
Short form?
Yes, sir. And just to clarify, the majority vote is to grant the MR, reverse the AT decision under Rule 22, and make the IC dated March 15th, 2020. And Commissioner Demerson, I have your short form dissent.
Thank you.
Case number 2632617, Commissioner Alvarez.
The AT decision is not supportable. The claimant was directed to a drug testing facility to provide a drug testing specimen. The claimant went to the lab but was unable to produce a specimen for 2 hours. He left the facility at its closing time and intended to return the following morning to provide the required specimen. The claimant has a medical condition that makes urination extremely difficult. He provided medical documentation of this condition to the commission, and the documentation from the drug testing facility also indicates that he takes medication commonly prescribed for this condition. The employer discharged the claimant before he could provide medical documentation to the employer. There is no evidence that the claimant was intending to avoid the drug test or otherwise acting in bad faith. His inability to provide a drug testing specimen did not constitute misconduct connected with the work. Reverse the 18, no misconduct, no chargeback due to MPI.
We should affirm the appeal tribunal decision. The claimant had the opportunity to stay at the lab until 6 p.m. to provide a sample, yet chose to leave rather than stay the minimum 3 hours required. According to the employer's policy, the claimant's refusal to cooperate with the drug test could result in termination. Because the claimant was aware of the policy, his actions constituted misconduct connected with the work. We should therefore affirm the AT decision, misconduct, no chargeback.
Affirm the AT, misconduct, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2639921, Commissioner Alvarez.
The AT decision is not supportable. The claimant in this case is a neurophysiology professional who worked at a hospital in 2-year fellowship. He was separated at the end of his fellowship. He sought continued work with the employer, but none was available. The AT cited appeal number 99-008549-10-0909999 from the appeals policy and precedent manual in support of its decision to disqualify the claimant. However, that precedent should not be held applicable to this case. In this case, the claimant in the precedent case has participated in training programs for which he or she was paid an hourly wage. Unlike the precedent case, the claimant in this case at hand had valuable skills to contribute to the hospital at which he worked. The employer in this case benefited significantly from the employment relations with the claimant, contrary to the typical work study or training programs envisioned by the precedent case, in which the program primarily benefits the participant or trainee. The claimant should be considered laid off when his employment ended and the employer had no further work available. Reverse AT, no voluntary leaving, bill reimbursing employer.
We should affirm the appeal tribunal decision. In accordance with Commission President, the claimant's separation at the successful end of the training program constitutes a voluntary separation without good cause connected with work. We should affirm the AT decision, voluntary leaving, reimbursing employer, not bill.
Affirm the AT, voluntary leaving, reimbursing employer, not bill.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2649356, Commissioner Alvarez.
The decision is not supportable. The claimant separated from employment on June 20th, 2020, which was later confirmed by the employer on June 23rd, 2020. She testified that she had difficulty contacting TWC due to the long wait times. Furthermore, the agency had been instructing claimants that claims would be automatically backdated. The claim should be backdated to June 21st, 2020. Reverse AT backdating granted to June 21st, 2020.
The AT decision is not supportable. The claimant delayed filing an initial claim after ceasing work in mid-June 2020 due to inability to reach TWC and lack of access to a computer. For purposes of good cause to backdate an initial claim, that would be sufficient. However, during the week in which she became unemployed, she gave birth and was in the hospital. After release from the hospital, she was in the process of moving and had no access to the internet and did not leave home due to concerns over COVID-19. Accordingly, we should reverse the AT decision. The claimant filed a valid claim, allow backdating to June 14, 2020, send a memo to UIO and CS regarding her medical ability to work and her availability for full-time work.
Reverse the AT, backdate the IC to June 14, 2020 memo to UIO and CS to investigate claimant's ability to work.
Let me just check on the date here. Ms. Miller, I will agree with both Chairman and Commissioner Demerson on backdating to 6/14/2020.
Thank you, sir. We have a unanimous decision.
Case number 2658174, Commissioner Alvarez.
The decision should be reversed. The Texas Workforce Commission stated repeatedly on Twitter that unemployment claims would be backdated when the claimant was affected by the pandemic. Executive staff also gave interviews stating that we would use the last date worked as the basis of the claim instead of when it was filed. To prevent injustice, Rule 22 should be applied to this claim. Reverse AT valid claim backdated to March 22nd, 2020.
The AT decision is supportable. The claimant could have filed his initial claim at an earlier point, but did not for reasons that had nothing to do with misinformation from TWC or to factors outside his control. That his employer ultimately did not compensate him for the pandemic-related furlough does not change the fact that he could have filed his claim earlier and simply reported any payment that the company may have ended up giving him. Accordingly, we should affirm the AT decision. The claimant has not shown good cause to backdate his initial claim.
Affirm the AT, backdating denied.
Long form dissent.
Commissioner Alvarez, I have your long form dissent.
Case number 2665200, Commissioner Alvarez.
The decision should be reversed. The Texas Workforce Commission stated repeatedly on Twitter that unemployment claims would be dated when the claimant was affected by the pandemic. Executive staff also gave interviews stating that we would use the last date worked as a basis of the claim instead of when it was filed. To prevent injustice, Rule 22 should be applied to this claim. Reverse AT valid claim backdated to June 14, 2020.
The AT decision is supportable. The claimant acknowledged that he could have tried to file his initial claim several weeks earlier than he did, but instead waited because he did not feel a need to apply and believed a press release from earlier in the year about backdating of claims would continue to apply later in the year. That does not constitute good cause for backdating an initial claim. Accordingly, we should affirm the AT decision. The claimant has not shown good cause for backdating his initial claim. In the alternative, I could agree to have this case resubmitted on a later docket with the discussion of when the Texas Workforce Commission's publicity about backdating of claims is intended to be effective. The question to be addressed would be whether the automatic backdating of claims was meant to apply to the period during which the call and the claim volume reached record highs, or whether it was meant to apply to a longer period of 2020.
I would agree to hold this case for the reasons that Commissioner Demerson indicated. However, I would, if possible, I'd like to go back and apply the same ruling to the previous case.
All right. I have a majority vote to resubmit the case with an analysis of when the agency intended public communications to relate that backdating should end. Did I accurately say that, Commissioner Demerson?
Yeah, and I'll read it again just so it'll be factual on the record. Agree to have this case resubmitted on a later docket with the discussion of when the Texas Workforce Commission's publicity about backdating of claims was intended to be effective. The question to be addressed would be whether the automatic backdating of claims was meant to apply to the period during which the call and claim volume reached record highs, or whether it was meant to apply to a longer period of 2020.
Thank you.
Thank you.
All right. And Mr. Chairman, we'll return back to the prior case, which is the 16th case, case number 2658174. And Mr. Chairman, you wanted to change your vote to the same, resubmit with that discussion?
That's correct.
All right. We no longer have a majority vote on that particular case.
I agree with the chairman on that.
Thank you. We will resubmit both cases.
Thank you.
Which takes us to the 18th case in today's list, case number 2674428. Commissioner Alvarez?
The AT decision is not supportable. The claimant stopped working on or about March 12, 2020, because she was ill with the flu. She saw a doctor, but was not able to obtain a doctor's excuse. When she recovered, she did not return to work because the employer's business was shut down due to COVID-19 pandemic. Reverse the AT decision, no misconduct, void chargeback. In the alternative, I would also agree to a rehear on this case. In her prior statement admitted to on record, the claimant wrote that when she had recovered from her illness, the employer had shut down. The appeal tribunal did not develop the record about this statement in the claimant's testimony. However, given that the employer is a salon, it is very likely that the employer would have shut down during the time period in which the claimant recovered from her illness pursuant to state or local mandates regarding COVID-19 pandemic. I would be willing to agree to a rehear on this case to develop on the record the issue.
We should affirm the appeal tribunal decision. The claimant's statements about going to see a doctor for her illness are inconsistent. She testified that she saw a doctor who diagnosed her with a fever, but in a prior statement to TWC, she said that the doctor told her she was fine, so she did not need a doctor's note. And in her appeal to the AT, she denied having seen a doctor at all due to COVID. These contradictory statements cast doubt on the claimant's credibility. What does seem certain is that the claimant did not update the employer on the status of her illness or her visit to the doctor. Because the claimant did not take steps to protect her job and failed to keep the employer informed, she voluntarily quit without good cause connected with the work. We should affirm the AT decision, voluntary leaving, void chargeback.
I would agree to the rehearing.
We will rehear the case.
Case number 2678313. Commissioner Alvarez?
The decision is not supportable. The claimant filed an appeal to the denial of regular unemployment benefits on 8/30/2020. The determination denying the claimant's unemployment benefits had not been posted, but just 15 minutes prior to this premature appeal, he had spoken to a claims examiner about his PUA. Agency personnel are not supposed to discuss decisions prior to them being officially posted because it is misleading and results to early appeals. The claimant in this case was misled into filing an early appeal, and his subsequent appeal should be deemed timely and resubmit.
We should affirm the appeal tribunal decision. The claimant received the determination in question, but did not file a timely appeal because he was not initially planning to appear and may have also misread the determination. As there are no good cause exceptions to the timeliness rules and no other filing in our records would constitute a timely appeal to the present case, the claimant's appeal is late, and we do not have jurisdiction to consider the underlying merits. Accordingly, we should affirm the AT decision. The claimant filed a late appeal, voluntary leaving, no chargeback.
Affirm the AT, untimely claimant appeal, voluntary leaving, no chargeback.
Short form dissent?
Yes, sir, Commissioner Alvarez.
Case number 2692998. Commissioner Demerson?
We should reverse the appeal tribunal decision. The claimant was discharged for being argumentative and unsubordinate with the employer. Two employer witnesses testified that the claimant's belligerent behavior and his insistence that the employer would have to fire him. Because the preponderance of the evidence established that the claimant mismanaged his position of employment, we should reverse the AT decision, misconduct, no chargeback, adequate employer response. In the alternative, we should rehear this case. In its appeal to the commission, the employer has offered to present an additional witness and has submitted new photographic evidence. Thus, we should rehear this case for testimony from this witness and for admission and review of the photographic evidence.
The decision should be modified, no misconduct, chargeback, and set aside adequate response. The claimant was discharged for alleged insubordination. The greater weight of the evidence indicates that there was a miscommunication with the customer regarding the repair of a violin. The claimant did his best to explain the issue to the customer and ordered a part for the customer. There was a disagreement with the owner and the claimant regarding the issue, and the owner eventually told the claimant to shut up, which the claimant objected to. As the claimant did his best to appease the customer and ordered the part as requested, his actions were not insubordinate, and his objection to being told to shut up was reasonable. Therefore, the employer has not shown misconduct. Modify the AT, no misconduct, chargeback, and set aside adequate response.
I would agree to rehear the case.
We will rehear the case.
Jerry, on the rehearing, I want to add this to, because the photos submitted by the employer were difficult to discern, we should instruct the employer to provide the photos in a format that maximizes legibility.
Yes, sir. We'll add that to the instructions.
Thank you.
Case number 2697183, Commissioner Alvarez.
The decision is not supportable. Due to a glitch in the employer's payroll system, the claimant received 3 weeks of salary 2 months after separating from the employer. The payments were not payments for services performed, a merit-based bonus, or attributable to any other category of reported income. Further, no testimony has been taken regarding whether the claimant was able to keep the money or whether the employer is seeking its return. Since the payments were not reportable income for UI purposes, there should be no overpayment. Reverse the AT, no overpayment.
The AT decision is fully supportable. It admitted that he was paid UI benefits during claim weeks in which the employer was paying him his regular pay. He was thus earning well over 125% of his weekly benefit amount and was ineligible to receive any UI benefits. It does not matter that the employer may have intended to pay him his regular wages during those weeks. That would be an internal payroll matter between the company and the claimant. The wages paid by the employer during the weeks in question were taxable wages. The claimant should not be able to double dip and receive more than twice his usual pay, including the $600 FPUC benefits for those weeks. Accordingly, we should affirm the AT decision. The claimant had an overpayment of UI benefits in the amount of $1,563.
Reverse the AT, no overpayment, resulting from an earnings adjustment.
Short form dissent.
Mr. Chairman, could you repeat your vote? I didn't catch it.
Reverse the AT, no overpayment, resulting from an earnings adjustment.
Got it. Thank you. And Commissioner Demerson, I have your dissent.
Thank you.
And that was the last pulled UI case on docket 5. I did previously send you the UI short form dissent list for docket 5.
We accept staff recommendations on the remaining UI cases on docket 5.
I second the motion except for those cases on which I'm dissenting as reflected on the UI short form dissent list for docket 5.
I concur with the chairman's motion except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 5.
Motion passes with the exceptions.
Thank you very much.
Thank you. This brings us to the end of agenda items 3 through 7. Let's pause for a few moments to reset for the rest of the meeting.
All right. Thank you, team. Mackin. Chairman, I was going to tease and say, do you want me to go try to find Commissioner Alvarez here?
No, he's back.
I know it.
And we're back.
Had to go.
Yeah, it was a thing, right?
It was a thing.
Let's go ahead and tackle agenda item 8. This is discussion, consideration, and possible action regarding the acceptance of pledges for the contract year 2020 and 2021 child care matching funds.
Good morning, Chairman Daniel, Commissioners, Mr. Cerner. For the record, Travis Weaver, Workforce Development Division. Today, Workforce Development, along with Child Care and Early Learning, are presenting for your approval BCY 2020 and BCY 2021 Child Care Local Match. I will present BCY 2020 first, request a vote, then proceed with BCY 2021 Child Care Local Match. First, BCY 2020 Child Care Local Match. Annually, staff presents Child Care Local Match amendments from boards requesting to increase their BCY 20 local child care match agreements previously accepted by the Commission as a result of contributors being unable to certify expenses for their original amount or to capture certifications from approved partners who exceeded their original pledge. Today's summary includes 25 match amendments from 10 boards: Borderplex, Concho Valley, Dallas County, Deep East Texas, Gulf Coast, Heart of Texas, Lower Rio, North Central, Northeast, and West Central. One item of note, as you may recall, on August 11, 2020, the Commission voted to provide BCY 2020 Child Care Local Match forgiveness for the following boards: Panhandle, North Central, Dallas County, and Texoma, for a total amount of $891,710. As a result of today's pending action, match forgiveness will no longer be needed for these boards. Today, staff requests Commission acceptance of child care pledges for donations, transfers, and certifications of expense for BCY 20 in the amount of $2,524,888. With today's action, the boards and the state remain secure. Commissioners, this includes my presentation for BCY 2020. I'm happy to answer any questions.
Questions or comments?
None here, Chairman.
None here. This is good work on getting these matches. Worked.
Do we have a motion?
I move that we accept child care match in the amount of $2,524,888 for board contract year 2020. I move that we accept child care match in the amount of $5,760,100 for board contract year 2021.
Second.
Okay.
Second.
Thank you.
All right, thank you. This is agenda item 9, discussion, consideration, and possible action regarding vocational rehabilitation vehicle modification services.
Good morning, Commissioners. For the record, Jason Vaden, Vocational Rehabilitation Division. Vehicle modification services provide a transportation option for VR customers whose disabilities prevent them from operating a standard vehicle. The goal of these services is to promote greater independence and access to communities, educational institutions, and other supports necessary to find employment, sustain work and living arrangements, and enable career advancement. Given the importance of these services, and based on the feedback from customers and stakeholders, staff undertook a thorough review of the vehicle modification process. Based on that review, staff identified several process and procedural modifications that will reduce complexities while also reducing the time needed to complete a modified vehicle. However, staff also identified a needed policy modification that would not alter eligibility requirements for VR services, but would impact a customer's ability to participate in vehicle modification services. Currently, before approving services, staff must determine whether other means of accessible transportation, including public transportation, are available to the customer, and that consideration be given to whether a customer should physically relocate to an area where public transportation is available. Given that the current criteria do not give a consideration to a customer's relocation and could result in a less desirable mode of transportation that could hinder achieving employment goals, that's direction on replacing the current criteria with those set forth in your material. including making the determination to approve vehicle modification services based on the benefit a customer would receive from a modified vehicle in order to achieve their employment goals, and ensuring that the customer has the resources needed to pay for associated cost of the vehicle once the vehicle modification process has completed. Commissioners, this concludes my remarks, and I'll be happy to answer questions if you have any.
Comments or questions?
No questions, Chairman, but I did appreciate Jason's report, and I love the flag in his background.
Chairman, basically, the RCT, I'm glad we had input from the RCT on this, and so appreciate that.
All right, do we have a motion on this issue?
I move that we replace the current criteria for obtaining vehicular modification services with determining whether the customer might benefit from the modified vehicle to gain greater independence and access, as discussed, and ensuring that customer has sufficient resources or will have sufficient resources through achievement of an employment goal to cover future costs associated with the vehicle, as discussed.
A second.
It's been moved and seconded. We're unanimous. Item 10, discussion, consideration, possible action regarding adoption of emergency rules 40 TAC Chapter 815, unemployment insurance regarding certain unemployment provisions in Public Law 116-260, the Consolidated Appropriations Act, which included the Continued Assistance for Unemployed Workers Act.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, I'm Jason Stolinsky, RID Policy Planning and Prosecutions. The Consolidated Appropriations Act, enacted December 27, 2020, contained the Continued Assistance Act, or CAA, which pertains to unemployment benefits. The CAA amended the CARES Act and other federal laws by, among other things, providing for an additional benefit program, state flexibilities, and new requirements concerning the coordination of programs. In terms of benefit payments, these emergency rules will allow the Commission to implement a new benefit program called Mixed Earner Unemployment Compensation. It operates similarly to federal pandemic unemployment compensation and affects certain individuals with histories of limited covered employment and independent contractor work. Additionally, new coordination rules could in some instances result in increased benefit payments to claimants by allowing them to stay on the pandemic emergency unemployment compensation program. Furthermore, these emergency rules allow the Commission to take advantage of the new state option for waiving overpayments which meet certain criteria under the Pandemic Unemployment Assistance Program. Previously, states were not afforded this flexibility under the CARES Act. Another CAA flexibility the rules adopt concerns state extended benefits. Under Section 209.025 of the Texas Unemployment Compensation Act, the Commission has the authority to adopt a new waiting period waiver from the CAA. This provision waives the 14-week waiting period that arises when a state no longer meets extended benefit criteria for 1 week, but does in a subsequent week. Finally, these rules include a conformity assurance section so that the agency will be able to adapt to any potential additional changes in federal unemployment law. During the surge of unemployment, it is vital that Texans have prompt access to the full extent of unemployment benefits available, including new benefit programs, options, and requirements provided by the CAA. Therefore, staff requests the Commissioners find imminent peril to the public welfare, which requires the adoption of emergency rules without 30 days notice in the Texas Register. On the same basis, staff also requests the Commissioners find imminent peril to the public welfare requires the adoption of rules with an expedited effective date that is effective immediately upon filing with the Secretary of State, so that these rules can be implemented immediately under the emergency rulemaking provisions of Texas Government Code Section 2001.034 and Section 2001.036. Staff will bring forward permanent rules to replace the emergency rules at a later date. Today, staff is seeking your direction on submitting these proposed rules to the Texas Register. If so directed, staff seeks approval to make any minor non-substantive corrections to the document for purposes of publication in the Register. I am here this morning as a resource to answer any questions you may have.
Any questions or comments?
None here, Chairman.
And just Jason, again, appreciate the briefing of this very complex article. Appreciate the briefing.
Thank you, sir.
Right. Do we have a motion on this issue?
On December 27, 2020, the federal government enacted the Consolidated Appropriations Act of 2021, which contained the Continued Assistance for Unemployment Workers Act of 2020. The Continued Assistance Acts amended the CARES Act and other federal laws in multiple ways, including an additional benefit program, state flexibilities, and new requirements concerning the coordination of these programs. Emergency rules are necessary to operationalize these new federal programs, state options, and requirements. During this surge of unemployment, it is vital that Texans have prompt access to full extent of unemployment benefits available, including new benefit programs, options, and requirements provided by the Continued Assistance Act. Out-of-work Texans who are struggling to pay their bills need access to these unemployment benefits. These benefits serve as a stabilization factor in our local economies, which are critically needed due to the statewide disruptions caused by COVID-19 global pandemic. I move that the Commission formally find that the immediate action is required to avoid imminent peril to the public welfare, which requires the adoption of emergency rules within 30 days, notice in the Texas Register, and with an expedited effective date that is effective immediately upon filing with the Secretary of State pursuant to Texas Government Code sections 2001.034 and 2001.036.
A second.
It's moved and seconded. Motion carries.
Thank you, Commissioners.
This is agenda item 11, discussion, consideration, possible action regarding the acknowledgement of gifts and donations of $500 or more in value given to the Texas Workforce Commission in accordance with section 302.021 of the Texas Labor Code and chapter 575 of the Texas Government Code.
Good morning, Mr. Chairman, Commissioners, and Mr. Cerna. For the record, Gabriel Flood presenting on behalf of the Office of General Counsel. Under relevant authority in Texas Government Code Chapter 575 and in Texas Labor Code Section 301.021, the Commission must accept gifts and donations with a value of $500 or more in an open meeting. For the first quarter of 2021, the only gift or donation with a value of $500 or more is a donation to the agency from Qualtrics LLC with a value of $807,765.07. The purpose of the donation is to make the donor technology available to the public who have questions about applying for unemployment insurance or TWC's other programs. Please note that in the materials, page 5 contains a resolution to be signed by the Commissioners for acceptance of the donation. Page 7 contains a description of the donation in accordance with Texas Government Code 575.004. Pages 9 through 46 contain the donation agreement that has been developed and reviewed in accordance with 40 Texas Administrative Code, Section 800.9. OGC has conducted our review and determined the donation meets statutory requirements. Accordingly, staff recommends acceptance of the donation. I'm available for any questions.
Any questions or comments?
None here, Chairman.
None.
Do we have a motion on this issue?
I move that we acknowledge the donation from a Qualtrics LLC valued at more than $500 as discussed by staff.
Second.
I just want to clarify, Commissioner Alvarez, you got $500. You cut out, I missed part of that. Your motion was to accept the gift, $500 or more.
Yes, sir.
All right.
As discussed by staff.
Okay, perfect. It's been moved and seconded. And motion carries.
Thank you.
Thank you.
Chairman, I'd like to add before we adjourn that on agenda item 10, I thought we were going to, well, we had two motions and I only referenced the one regarding the Texas Government Code sections of 2001, 034 and 036. I didn't include the second motion, which was the second part of Jason's discussion or presentation, I should say.
Okay.
So would it be appropriate to go back and now reference my second motion, which I probably should have included?
We can. We're going to go back to agenda item 10 and take your second motion.
Thank you, sir. If I may, I also move that we adopt on an emergency basis pursuant to Texas Government Code Section 2001 301.034, Texas Labor Code sections 209.025 and 301.0015, A6, and 301.062, the proposed amendments to Chapter 815 rules relating to the unemployment insurance benefits, general provisions in Section 815.4, extended benefits in Section 815.175, and CARES Act provisions in Sections 815.180 through 815.185, and publish them to the state register with permission for staff to make minor non-substantive changes.
Yes, I second that.
It's been moved and seconded, and the motion carries.
Apologize for that.
No worries. This will bring us back to agenda item 13. Discussion of serious possible action regarding guidance on resource utilization, implementation of services and strategies to target disaster relief efforts and public health emergencies, including those funded with the Department of Labor's Disaster Dislocated Worker Program.
Mr. Chairman, Commissioners, for the record, Ed Serna, Executive Director. We have 4 update reports for you today, starting with Clay Cole over UI, and then we'll proceed with a child care update, a workforce update, and then finally a vocational rehabilitation update. So with that, I'll ask Clay to provide an update.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, Mr. Serna. For the record, Clay Cole, Unemployment Insurance Division. Today, I'm following up with the UI update regarding your request last week, Chairman, for an update of all measures taken in response to the COVID-19 pandemic, in general, where we've been and where we are today. Beginning in March through yesterday, March 2020 through yesterday, TWC's paid out approximately $40 billion in unemployment benefits and processed over 7 million claims. And just to put this in perspective, if you look at calendar year 2019, there were 738,000 claims. Compared to the last 11 months, over 7 million claims. That's a 948% increase. And if you compare the $2 billion paid out in calendar year 2019 with the $40 billion paid out over the last 11 months, that's a 2,000% increase. In fact, in comparing March 8th through March 8th, 2020 through yesterday, the 11-month period, the claim numbers were even higher for that 11-month period than the last 6 years combined from 2014 to 2019. And to handle the surge and assist our fellow Texans, we needed more technology, we needed more staff. The Unemployment Insurance Division took immediate action by converting 450 current TWC employees from other departments to assist with UI claims. And we assembled approximately 1,514 volunteers, even including volunteers from our own Texas State Senate and Texas House of Representatives. Vendor partners contracts were immediately signed, thereby doubling the number of active call centers from 4 to 8 call centers and increasing total claims processing staff to 3,392 individuals. During this time, TWC UI and our partners received a staggering 173 million calls. In addition, a virtual telecenter was also implemented for intake and inquiry calls, routing them to the first available and appropriately skilled customer service representative in any telecenter. Also, changes associated to the pandemic programs. We were able to increase workloads. The UI division rose to this challenge by a record-setting productivity of 8.5 million assignments handled, which was a 727% increase compared with 2019. Proactively, TWC anticipated calls would continue to increase. Therefore, we expanded our call center hours of operation to 12 hours per day, 7 a.m. to 7 p.m., 7 days a week, which we continue to do today. We also increased our server capacity for our UI claim systems from 5 to 20 servers. An interactive automated web chat bot program was created to handle frequently asked questions from customers and employers. Larry the chatbot answered 11.5 million questions during this time period. And a new and secure online document upload portal was also implemented in order for claimants and employers to more effectively provide necessary documents. TWC also created a unique claims handling tool the DUA Worker app to distribute claim task items to TWC staff, volunteers, and contract call centers, which expedited claims handling and processing. Additionally, TWC engaged with another partner to deploy a cloud-based interactive voice response system to improve services. Since going live, the interactive voice response handled more than 11 million calls. And in addition, the interactive voice response includes a chatbot that leverages speech recognition and provides answers to common unemployment questions. To aid our fellow Texans who lost their job, TWC also suspended work search requirements, waived the waiting week, and temporarily suspended offset collection efforts for claimants who owe prior debts to TWC. As you remember, on November 1st, work search was reinstated for most counties in Texas. We also assisted Texas employers by waiving chargeback requirements for covered employer layoffs due to COVID-19 and continue to search for ever available options that will help all employers recover and rehire their staff as Texas works to return to normal. For appeals hearings, again, the pandemic brought extraordinary challenges with about 1,000% increase in hearings from an average of about 2,200 per week pre-COVID to an average of 22,000 appeals received per week since COVID-19 struck. Also, the same lines of our claims area, in line with our claims area, our appeals department hours were extended to 7 p.m. during weekdays, and we added Saturday hearings as well. We immediately brought on additional staff in appeals as well. But as you know, attorney staff that hold the unemployment hearings have a little more limitations on recruiting from other departments. These positions are harder to fill. Nonetheless, we did have an additional 62 volunteers from other areas that have since begun returning to their primary duties. So we don't have as many volunteers now, but continuing to assist, we were able to bring on an additional 160 additional appeal staff from direct hires through temporary agencies by working with contractors. We have access to attorney job seekers as well. And because of these additional hires, the next week we've scheduled over 5,000 hearings, which is a record for us, and we'll continue to work to increase that productivity. The Texas Workforce Commission continues to explore options to keep the 2021 tax rates as low as possible for Texas employers as Texas and the entire nation continue to deal with the economic disruptions of COVID-19 pandemic. TWC is partnering with federal and state officials on ways to reduce the impact of COVID-19 on Texas employers. We knew January would be an extremely busy month with all the new federal legislative changes under the Continued Assistance Act extensions, also being a change of quarter month and distributing over 2.9 million 1099-Gs. On top of that, we've experienced an increase in claim activity compared with December. Along with our IT and external relations teams, we've successfully implemented the vast majority of the Continued Assistance Act programs that extend the pandemic emergency unemployment compensation, pandemic unemployment assistance, federal pandemic unemployment compensation, and state extended benefits programs. We continue to update approximately 10 to 20,000 unique customer claims of the over 1.2 million claims extended, as well as introducing overpayment tracking and mixed earners unemployment compensation automation under the federal programs. TWC did complete the distribution of the 1099-Gs to roughly 2.9 million individuals paid in 2020. Things went smoothly. However, we are receiving relatively small number of inquiries from individuals that received a 1099-G, however indicated they never filed for unemployment, an even smaller number of customers that did not receive a 1099-G that were initially under investigation for potential ID theft. And staff are working closely with these customers to resolve their inquiry. The UI team realizes the race is far from over. We continue implementing solutions to better serve our customers through new technology, continuous process improvement, staff development, increased resources, and strategic communication. We continue to work very closely with all our partners to improve customer service. UI teams, partners, and volunteers have been relentless and remarkable in responding to the pandemic. and I assure you, we are nowhere near done, and we will continue to further improve our service delivery for our fellow Texans. This concludes my update, and I'll be happy to answer any questions you may have.
Thank you, Clay. Any questions or comments?
Chairman, I'd just like to take this opportunity to thank Clay and his staff for a detailed report. It's obvious we still have challenges, and I appreciate the fact, Clay, that as these challenges come up, that you address them. So thank you for that. And thank you for improving the wait times. I know that seems, again, your staff, the call center folks have done an excellent job of responding as quick as possible. And I just wanted to take this opportunity to thank you for that. And please convey that message to everyone in your staff. And again, our frontline workers there with the call centers.
Thanks, Commissioner Alvarez. You're welcome, and we'll let them know. Appreciate it. Appreciate the support.
I wanted to just kind of let you guys know, I appreciate the team's work on exploring ways to keep employer tax rates low, all the creative thoughts that are going into that, and the office will continue to be a resource for you guys as much as we can as we proceed forward with those rates. Thank you for what you guys are doing.
Thank you. And yeah, we'll continue to work closely with you, Commissioner Demerson.
Clay, thank you. Great report. Lots of things going on. We've got more work to do, as you've already pointed out. I know you guys have been at it for a long time, and I appreciate your willingness to continue to innovate and provide customer service that Texans should expect from us. And so we'll keep working toward that end. Let us know if you need additional resources or what you may need, but I know you have been thinking about these things and obviously have a plan of action in place, and you're working your plan.
Thanks, Chairman Daniel.
Next, we have an update from Reagan Miller on our child care activities.
Good morning, Chairman, Commissioners, Mr. Cerna. For the record, Reagan Miller with the Child Care and Early Learning Division. This morning, I'm happy to provide you with an update on actions the agency has taken to address the child care impacts of COVID. With the first set of federal funds approved under the CARES Act, Texas received about $371 million in child care development block grant funds. With those funds, we immediately implemented a child care program for essential workers, enrolling over 29,700 children from April through May 20th, with each child receiving 3 months of child care. This was done at the time schools across the state were closing, and many parents had not planned for nor budgeted for child care. We supported this using approximately $55 million of the CARES Act funds. We also increased funds for our low-income program in both board contract year 20 and 21, investing about $52.5 million here. And finally, the majority of these funds were invested to support a temporary enhanced reimbursement rate for subsidy providers who have been experiencing overall higher costs during the pandemic. Over $253 million has been budgeted to support this temporary enhanced reimbursement rate, which began in March 2020 and will continue through July of 2021. In addition to the CARES Act funds, the Texas Workforce Commission also addressed the impacts of COVID using existing child care funds. At the beginning of COVID, when the governor's executive order had closed all regulated child care to everyone except the children of essential workers, TWC put in place a temporary measure to pay the parent copay. During the 2 months that this was in place, we invested about $20 million. We also supported child care providers who closed following COVID in the spring of 2020. Through the end of May, we continued to pay providers based on the number of active referrals they had in place at the time they closed. Then in June, we implemented a child care stabilization grant for closed subsidy providers who planned on reopening around the time school started. So looking from June through September, we supported 59 providers in June, 54 in July, 42 in August, and 30 in September, and provided almost $750,000 to help them pay for those fixed costs while they were closed so they could reopen. And today, we continue to support subsidy providers who must temporarily close due to confirmed COVID cases. Boards can pay for closures that last up to 2 weeks, and anything that goes beyond 2 weeks may be considered on a case-by-case basis with TWC approval. And we also use some of our regular childcare funds to develop a new online childcare availability portal. This website remains up and running and allows parents to search for available childcare seats across the state. And then, as Travis Weaver just mentioned in his childcare match agenda item, you did approve match forgiveness for 4 boards as a result of COVID. But fortunately, as Travis mentioned, those boards were able to identify sufficient local match, and so that match forgiveness is no longer needed. We also took several program and policy actions to help address the COVID impacts to childcare. From March through November, TWC waived its rule regarding work requirements and extended the length of time parents had to secure employment if they lost their job. And during this time frame, we also allowed for the blanket extension of eligibility redeterminations. Regarding our policies for how we pay providers, we have existing policy and rules that we pay providers based on the enrollment of a child. And we couple this with our rules on attendance standards. And after 40 absences, a child's eligibility may be terminated. However, during COVID, we have waived the 40-day absence policy, and this waiver remains in effect today. I'll also highlight the work that we did with the Texas Division of Emergency Management, or TDEM, to help childcare providers access PPE and cleaning and sanitation supplies. Early on in the pandemic, those materials were really hard to find. So to help them, we were able to use that online availability portal to reach out to providers using the system. TDEM helped with 3 rounds of distributions, making those available across the state through the local Texas A&M AgriLife locations. We had over 3,300 providers in June and again in July, and then 1,400 providers in August that were able to purchase supplies through this new distribution chain. In closing, I'll mention, of course, the new COVID release package that was signed into law at the end of December. We still have not received official guidance from the U.S. Department of Health and Human Services, but estimates show that Texas will receive over $1 billion in federal child care and development block grant funds. And of course, we'll continue to work with you on our future strategies to invest those resources. That concludes my presentation.
Thank you. Questions or comments?
None here, Chairman. Good report.
All right, and thank you guys and Ed for the excellent work in the child care space. Essential work is very, very, very necessary, and I like the fact that we've been very proactive in a lot of ways, and it's a good report with a lot of good information, and it shows what we've been doing in that space.
Thank you.
Now, Courtney Arbor with a workforce update.
Morning, Commissioners. Mr. Cerna, Courtney Arbor, Workforce Division. I have a few updates related to the Workforce Division COVID recovery activities. As you know, many of these activities are, which were approved by the Commission, are carried out by agency staff in multiple divisions, workforce boards, AEL grantees, and other partners. On the employer front, most notably, the Workforce Division and Employer Initiatives continues to work with employers and partners to provide training in the Skills Development Fund. Since May of 2020, when you all approved funds specific for this purpose, a little over 12 million was made available and is in grant contract with a planned number to train of almost 8,200. 4,626 people have been trained to date in that program, and we're hearing great feedback about the flexibilities that are afforded through that contracting process. And employers have really been able to adapt to what they need as quickly as they need to for COVID. Training is in topics like safety, disinfecting, patient care, manufacturing, and they're also using it to provide new skills to workers and also to transition their operations to more COVID-related needs. So that we're hearing, again, great things about the skills development flexibilities. In January, we continue to see increased enrollments in the metrics online learning courses that you all approved very early in the pandemic. Texans began using it in July 2020, once we were able to get under contract. And as of the end of January, we have close to 53,000 folks registered in the metrics online learning platform. They've completed 92,721 courses and about 90,000 learning hours. So they're able to add that to their resumes and mention that in interviews. And they're able to go on, if they would choose to do this on their own, and get certifications, go on for testing for certifications. The call centers that the Workforce Division procured have outreached 657,355 claimants to help them connect with local offices and other resources they may need, helping 54,170 to register for work and answer questions about uploading their resumes and finding help with that if needed. Through the WIOA funded grants that you all approved at the very beginning of the pandemic and were awarded in May 2020, 424,032 Texans have received services through virtual job readiness, coaching sessions, occupational training, boot camps geared to specific occupations that are in demand in their areas. The grants have supported 8,276 employers with rapid response activities and layoff aversion, which, as you know, commissioners, helps to offset some costs that they've faced during COVID and also help them address the challenges with staffing and sometimes even assist with layoff and helping those workers to connect to resources and transition to other available positions. With that grant, the WIO funds, boards have also purchased technology platforms to expand and continue their virtual services, which continue on today. TANF funds that you all approved again in, I believe it was April, very early in the process, have also provided similar support for boards. They've been able to support the purchase of the technology platforms and keep the doors open even when the doors weren't open. We'll be briefing your offices on the specifics of the expenditures later this month. The largest of all the grants in place administered by the Workforce Division is the Department of Labor's disaster grant. That was subgranted to boards at just under $39 million is the total grant for TWC. We were congratulated, commissioners, I wanted to share with you and Mr. Cerna that we were congratulated by the Department of Ed for the Texas performance on this grant. Over $4.5 million of that funding have already helped 757 Texas and the employers they're hired with participate in paid short-term employment that provides disaster relief and recovery in local areas and also provides career and training services to everybody that's enrolled. Boards continue to focus on increasing the enrollments in meaningful job activity for anyone that is enrolling in that program. I wanted to highlight something Tarrant County Board is doing with their grant dollars that DOL congratulated them on, and we've been excited to see. Through these grants, they've purchased some technology that helps them outreach and screen potential job candidates. And in partnership with the health department there in Tarrant County, the board has been able to do pre-screening of a number of applicants for some of those crucial jobs that the health department has, so that by the time, very quickly, the board has been able to send referrals over to the health department. And the health department then can select from a small group of highly qualified Texans and fill their positions very quickly. So that's one example of some of the partnerships that are growing and being strengthened through the innovative purchases and work that has come about because of this, the shift in service delivery. With the IKEA donation that you all approved last month, staff in many areas of the agency are working on projects to provide data analytics and tools for employers as they transition to curbside, contactless, and learning more about how COVID has changed their consumer behaviors. The Home Project provides funds to boards to directly support employers as they transition to telework and contactless. Texas restaurants will benefit from the Restaurant Recovery Initiative. That is the partnership we have with Texas Restaurant Association, providing instructional videos with tips on going and staying curbside and contactless, also providing food handling permits and ServSafe certifications to Texans at no cost, so they can go to work in the industry as that very valuable industry continues to bounce back. Job seekers, again, through the IKEA project, job seekers are benefiting through a pre-apprenticeship program, specifically young people who will be able to start in a program that will lead them either into higher education in that field or into a full-blown registered apprenticeship program. The funds also provide grant-supported consumable supplies. These projects were approved just last month, but they're in development now, commissioners, and we'll give you updates along the way. The last project funded with the IKEA donation was the My Texas Career Portal, which launched last month. We're hearing good feedback from users. That is all the employers who are in work in Texas are fed into this job matching portal, and users, those claimant or customers and others that wouldn't traditionally use our system can go in a very quick, streamlined fashion, upload a resume and begin job matching. On the AEL, adult education front, we continue to provide support to providers as they support students in an all-new learning environment. Since you all granted funds specific to virtual and remote learning in May 2020, providers have made it available, with about 40% of all of our AEL learners now using a virtual or a hybrid process for their AEL classes and support from their instructors. Our enrollments are lower than we'd like. Right now in AEL, we're at just under 24,000, which is much lower than we normally would be at this time. But honestly, all states are struggling in this area. And commissioners, because you all have been focused on virtual means for adult ed in past years, we were on good footing, better footing than many states going into this pandemic. So we're hearing on our calls with Department of Ed and other states that really, as much as we hate to see these low numbers, and we're working hard to get more adult ed students enrolled and engaged through these hybrid models, it's common across the U.S. I'll just make one more mention that the Workforce Solutions offices continue to provide services either by walk-in with the doors fully open or by appointment. Everybody continues to do one or more services virtually, just as a way to bolster the services that are available out there. They're having many hiring events, most virtual to date since the pandemic. And I believe we started calculating this in May of 2020. We've had the local offices have hosted 717 virtual hiring events, 119 in-person hiring events, and those events represent 229,000 job openings with 8,616 employers participating. So clearly a lot of hiring going on, and good work continuing, whether in person or virtually. That concludes my update. I would be happy to answer any questions you have.
Any comments or questions?
Chairman, I have a comment for Courtney. Courtney, I want to thank you, your staff, of course, the agency as a whole, for how quickly Workforce pivoted to meet the demand of not only the employers, but job seekers. Thinking outside the box, as you've heard me mention multiple times, I appreciate that. And I also appreciate the fact that you, Ed, and other members of our team meet with our local workforce boards to kind of provide them with updates. I really want to compliment, and I actually should say I want to thank Ed for allowing those that have made a presentation today at this particular agenda item. Very good information. Again, I would encourage not only staff to be a part of these discussions or listening to our commission meetings, but also our boards. I think there's a lot of important information that you're sharing, especially when you talk about Tarrant County or other communities. I think they need to be recognized for all the great work that they do. But again, this is a team effort, and what you have put together with your staff to make these programs and these opportunities available to job seekers and assisting employers is very crucial. And we all understand that we have challenges, and we can't forget that we have folks that are waiting still online to get through, but we're doing it together. And so I'm glad that those that are on listening to today's call are hopefully they're paying attention to some of the good things that the agency has done, even though we're facing challenging times. So thank you, Courtney. And again, convey that message to your staff.
Thank you, Commissioner.
Commissioner, I'm excited. I mean, I've heard from Clay, Reagan, and now Courtney. I mean, the ball is moving, and it's been moving, and we're doing some phenomenal things, and that's heads off, Ed, your leadership, and Courtney, and you guys, and what you're doing. If I can do anything from my standpoint, I'm right there with you guys. But I love the fact Tarrant County utilizing that technology. I was talking to Paul Fletcher the other day, one of the local boards, and he was sharing with me the retail analysis that's going out, and how he has the 5 there, and how his community is excited about putting that out and putting it to work. And that tells me that you guys are taking what you have and putting it out there in the community. The boots on the ground at the local level, and that's where everything happens. And I'm excited to hear about what's taking place. So good work. Thumbs up, as they say. Appreciate it.
One last presentation from Cheryl Fuller, and then that concludes our presentation. One quick thing, though. I'm sorry, Cheryl, interrupt you. One quick thing. Commissioners, I wanted to add that Courtney didn't mention when she talked about the call centers and the number of people that they have reached out to and worked with. One thing that she didn't mention was that we had about over 40,000 that they didn't need to call us back, but they called us back and told us that they had found employment already. some of those contacts. So just want to make sure that y'all were aware of that as well.
All right. Good morning, Mr. Chairman, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, Cheryl Fuller, Vocational Rehabilitation Division. Since the onset of the COVID-19 pandemic in Texas last March, the VR division has focused its efforts in three primary areas. First is adapting our business processes and service delivery strategies to ensure continuity of services to our current customers, access to VR services for new customers, and to implement innovative ways to serve all our customers using technology. Second is we focused on improving our services by collaborating with providers and stakeholders, and also focused on improving our internal processes using rapid process improvement. And third, we have focused on developing plans to maintain what is working and continue to identify and implement innovative strategies for service delivery after the pandemic. So this morning, I'd like to share just a few highlights from each of these focus areas. Adapting business processes and finding innovative ways to use technology. On March 30th, just 2 weeks into the onset of the pandemic in Texas, we issued temporary exceptions to our business processes to enable our staff, providers, and customers to receive, sign, and submit documents electronically. The exceptions also enabled us to move to virtual strategies to continue services to current customers and engage new customers. Not only are these exceptions important for service continuity, they also improve ease of access for our customers and reduce their need to travel to an office or another location to work with us. To maintain these improvements, in September, we incorporated many of them into our standard business processes. Throughout this time, we've also worked closely with TWC IT, not only to ensure that our staff are equipped to work and serve customers remotely, but also to continue to identify and implement technology solutions to better engage and serve our customers. To highlight just a few of those, shortly after it launched, we added VR questions to Larry the Bot, which has provided VR information to 8,280 individuals to date. We established a small rapid engagement team that is available to interested individuals through one statewide number and email address. Since its launch in July, this team has connected 2,456 individuals to VR. We also adapted a virtual hiring fair platform by using it to provide career exploration activities to students with disabilities. By the end of 2020, VR staff had conducted more than 25 virtual student transition fairs attended by more than 2,000 individuals. In just a few weeks, we will launch a portal that will enable interested individuals to self-refer to VR by clicking a link on our website. And we're working with IT and business operations on an automated attendance system that will facilitate ongoing communication and increase engagement between VR staff and customers. With regard to improving our services and processes, we have collaborated with our providers and stakeholders to increase the efficiency and quality of our services by taking an in-depth look at where we need to improve. They've provided input about challenges, recommended solutions, and they're providing ongoing feedback on our efforts to improve the modification process that you just heard about earlier this morning, the employment services we offer, our supported employment services, and also services to our customers with mental health conditions. In addition, we're using what we've learned about rapid process improvement to deploy tools and techniques that help our VR counselors, rehabilitation assistants, and unit support team members to work together to serve their customers. As we prepare for the future, we understand that the future of service delivery and customer engagement will be different than what we did before the pandemic. And we're excited about our plan to adopt a hybrid approach to service delivery. Our goal with this plan is that our customers will be able to choose whether to engage with us in person, remotely, or both. We're also working with IT on solutions to move more toward a paperless approach. We're doing this by implementing systems that enable electronic document transmission and storage. And in fact, we're currently piloting a new system that will allow providers to submit reports and invoices electronically, that will then be stored electronically and connected to the customer's case file in our case management system. We are also looking forward to serving students this summer. Last summer, we were able to convert about 17 of our planned summer programs to virtual formats, serving over 1,100 students. However, we were so disappointed to have to cancel our largest summer program, Summer Earn and Learn. It was necessary, though, for the safety of our students and communities. But this year, as of last Thursday, we've executed contracts for Summer Earn and Learn 2021 with all 28 workforce boards. And our goal with our workforce board partners is to provide work readiness training and work-based learning to more than 2,500 students this summer. And this year, we have included options for virtual work readiness and remote. So while the pandemic has been very challenging for the VR program, and especially for our customers, the last almost year has given us an invaluable opportunity to adapt, to improve, to innovate, and to plan for the future. And we've been able to do this at an accelerated pace thanks to the support from other TWC divisions, including IT, business operations, operational insight, and external relations, and also thanks to the support and engagement from all stakeholders and providers. As we ended 2020, for the calendar year, more than 22,500 people applied for VR. More than 56,000 of our VR participants received services to help them prepare for, obtain, and retain employment. And more than 10,000 of our participants completed their planned services and achieved successful employment. So we are committed to continuing to implement what we've learned and improve as we go forward. That concludes my remarks, and I'd be happy to answer any questions.
Any questions or comments?
Thank you, Ms. Fuller. Great report.
Cheryl, I'm going to continue to recognize employers that are playing in that disability space, that invoke re-out space, and I look forward to doing that and working with the RCT, pushing forward in that regard. So thank you for what you're doing.
Yes, sir.
Thank you.
All right. Thank you.
Thank you, sir. That's the last update that we had. That's it for this agenda item.
All right. Thank you so much. This is agenda item 14, discussion, consideration, and possible action regarding approval of local workforce development board nominees.
Morning, Chairman, Commissioners, and Mr. Cerna. For the record, Shanta Williams with the Workforce Development Division. And before you for consideration today, we have workforce board nominations for Workforce Solutions Alamo, Borderplex, Deep East Texas, North Central Texas, and Golden Crescent. Staff recommends that all nominees be approved, and I'm here to answer any questions you may have.
All right, questions or comments?
None here, Chairman.
None.
All right, do we have a motion on this issue?
Chairman, I move that we approve board nominees for Alamo, Borderplex, Deep East Texas, North Central Texas, and Golden Crescent.
Second that motion.
Been moved and seconded. Motion carries. All right. Agenda item 15, we don't have any legislative proposals to discuss today. Is there a legislative report today?
Yes, sir, there is.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, Michael Britt, Governmental Relations. Currently, the Texas House and Senate are adjourned until next Tuesday, February the 9th. The House will reconvene at 1 o'clock on Tuesday and the Senate at 3 o'clock. It's also being reported that House committee assignments will be released sometime this week. And finally, wanted to update you all that the Senate Finance Committee has scheduled their hearing for Articles 7 and 8, which will include TWC, for Thursday, February 18th at 9 a.m. The exact order of the agencies for the hearing and protocols for personnel testifying are still being finalized, and we will keep you updated as those become more clear. And that concludes my remarks, and I'm happy to answer any questions that you all may have.
Thank you. Any questions or comments?
None here, Chairman.
None. Thank you.
Thank you very much. All right, now an executive director's report.
Yes, sir. I have one item that Tom McCarty will lay out for us.
Good morning, Chairman Daniels, Commissioner Alvarez, Commissioner Demerson, Tom McCarty with External Relations. It's my pleasure to present to you all that Kim Berry was nominated by her supervisor, Michael Britt, for the Individual Star Award due to her demonstration of dedication and service to the Governmental Relations Department and the agency during the 86th Texas legislative session. I'll provide a few highlights from the substantial write-up of Kim's actions as it relates to this award. While maintaining her own assignments and workload, which during a legislative session is significant, Kim, on her own initiative, trained new staff on departmental daily and legislative operations, software used by the Government Relations Department, and invited staff to meetings to help build knowledge in program areas. Her actions not only demonstrated clear performance above and beyond her assigned duties, but also demonstrated the very definition of teamwork. Please join me in congratulating Kim and thanking her for her exceptional service to the agency.
Thank you.
Did you want to have
well-deserved award?
Did you want to have Kim say anything?
I think y'all can see Kim on your screen now.
There she is. Kim, you want to say a few words, or are you good?
I'm appreciative and just thank you, and I'm lucky to work with a very good team.
All right. Congratulations, Kim. Good job.
Congratulations, Kim. Good job. That's well deserved.
Kim, I gave you the hand clap, so appreciate all that you're doing. And so, got it.
Our legislative folks normally work behind the scenes, so it's always fun for me to bring one of them out into the light, especially for one that's done an outstanding job. So, Mr. Chairman, that concludes the Executive Director's report.
Thank you so much. Is there any other order of business come before the Commission today?
Chairman, I'd just like to acknowledge that February is two things that are very dear to me. One is CTE Awareness Month, and the other is celebrating Black History Month. So I'd like for everyone to join me in that.
We're joining you in all of those as well.
Absolutely. Absolutely. Anything else? Do we have a motion to adjourn today?
Chairman, I move that we adjourn.
I second that motion.
Been moved and seconded to adjourn, and we are adjourned. All right. Have a great week.